Attorney Stern.
Good morning, Your Honor. My name is Donald Stern, and I represent Boston Medical Center and Boston Medical Center Health Plan. This is an appeal from the Superior Court's judgment on the pleadings against the plaintiffs. And this case is consolidated with another companion case involving Holyoke Hospital, and Janet Lumberg, who's here, will be representing Holyoke Hospital and her clients. We've been allotted 20 minutes between us, so we'll split that in half. This case is critically important for two reasons. The first is that it really may determine the future of Boston Medical Center, the medical center which serves the largest number of poor people and poor patients in Massachusetts. And it's a hospital which historically has played a central role in treating a large, in fact, the largest underserved population in Massachusetts. But also involves a legal principle which is very important, and that is whether the Secretary has completely unfettered discretion to set a rate for Boston Medical Center when it serves underserved, disproportionate share patients for whatever rate she chooses, without any possibility.
Mr. Stern, I'm sorry. Unfettered? I mean, it doesn't have to get some form of approval, at least the methodology from the federal government?
There is some, and I'll get to that, Your Honor. There is some ability to review at the federal level. We think it doesn't necessarily mean the same thing, although it's parallel in many respects to what the state requires. But that's one of the claims that we never had an opportunity to pursue, whether that federal standard had been set. But just focusing in on the state provisions, what we think the end result of what the Superior Court did here is that it's at least a take it or leave it possibility. What the Superior Court judge said is that Boston Medical Center had voluntarily agreed to participate in these programs, and whatever rate the Secretary chooses to set, whatever rate that is, Boston Medical Center has to take it or leave the program entirely. What I'd like to do is to just set out what I think are the three flaws in the Commonwealth's position, one of which Justice Cordy already portended, which is the federal issue, and then give you a little bit of background into the dispute. The three flaws is, first of all, we think it's wrong that the lower court found that there was no judicial review whatsoever. We think that the court can infer from the statutory scheme and from the context that there has to be some judicial review. The second flaw has to do with the takings claim. And what the Superior Court judge said was that Boston Medical Center had the option. It could walk away entirely from treating needy patients, from poor patients, and it could go on its own. We think that's wrong legally. We think it's wrong factually. And then the third flaw deals with this Supremacy Clause claim. We were never permitted to make any of these claims, to do any discovery, to have our day in court, because what the Superior Court judge did was essentially said, and it kind of conflated private right of action and sovereign immunity together in the concept of judicial review, said there was no ability under any theory to challenge what the Secretary did. So, quick background. Boston Medical Center is a merger of statutorily authorized, contemplated merger between the old Boston City Hospital and Boston University Medical Center. And in that statute passed by the legislature, Boston Medical Center, it made clear, has to treat all comers, not just in an emergency care situation, has to treat all comers, provide accessible health care to all in need, regardless of the status or ability to pay. And clearly, when you read that statute, the legislature understood that Boston Medical Center depended upon government reimbursement. It was to maintain its status as a public service hospital. And Boston Medical Center has met that challenge and met that mandate. It plays a unique role in the city, a unique role in the Commonwealth. It serves probably 70% of its patients are Suffolk County residents in underserved population, mostly Mattapan, Roxbury, and Dorchester, and serves something in the range of 150,000 per year of safety net patients. And in deference to that unique role, the legislature has carved out really sort of two income streams and several other income streams which pay special attention to the disproportionate share nature of Boston Medical Center and its own very unique role. One is the Section 11 payments, which I'll talk about in a second, and the other is the Chapter 122 payments, which were designed as a 3-year transitional income stream as Massachusetts moved from one healthcare model to the second. In Section 11, typically contracts between providers are worked out between the secretary, and the contract rate is a semi-negotiated rate. But the legislature said that may be true, but when you get to disproportionate share hospitals, the system's different. When we get to Section 11A, the system is different, and clearly there's a legislative mandate that the rates must equal the financial requirements for providing care to recipients of medical. I'm sorry, Justice.
I'm a little confused.
Yeah.
I'm a little confused as to this category of DSH hospitals.
Yes.
And the Boston Medical Center's claim of, sort of having a unique role. Is it uniquely the DSH, or are all of the plaintiffs in this case DSH hospitals?
All the plaintiffs. For purposes of Section 11A, all the plaintiffs are DSH hospitals. The Secretary has interpreted Section 11A with respect to BMC somewhat differently over a course of 18 years than at some of the other DSH hospitals. So, for example, BMC was excluded and didn't have to comply with some of the efficiency standards, having in mind that it was a different model. It provided different services. Its population was different. But the statute applies to all the DSH hospitals.
All right. So the DSH hospitals include Boston Medical Center. But are all DSH hospitals under the same mandate that they can't decline to serve any low-income patients?
Yeah, I think there's some differences with BMC. All of the DSH hospitals, all not charitable, nonprofit hospitals, share certain similarities. They have certain requirements. Some of those requirements, in fact, get enforced by the State Attorney General's office. But BMC is, I think, a category of one, in the sense that it really has a statutory mandate over and above what usually would apply to DSH hospitals, over and above what would usually apply. So this notion that they could kind of walk away from the program, that they could leave the Medicaid program, leave mass health, leave those programs, and somehow treat patients and never get paid for it, is a recipe for disaster.
Can a DSH hospital decline to serve mass health members?
I'm not sure that they can. They probably can't. But I think they could. They certainly don't have the statutory legal requirement in the same way that BMC does. And hospitals are different than physician providers. A physician can take his or her practice and move it elsewhere. Boston Medical Center is not moving to fulfill the unique role that it plays in the city of Boston for the patient population it serves. It's the classic Hobson's choice. It has no legal or factual alternative but to serve poor patients. And the net result, by the way, of all of the rate machinations the Secretary has undertaken is that Boston Medical Center now gets something on the average of 64 cents for every dollar that it spends on poor patients. 64 cents.
But you still get much more than other hospitals.
You get much more because the needs are greater. They're greater in terms of the number of patients who are being served. And by the way, that's not necessarily true, Your Honor. When the Secretary reset the SPAD rate, most of the other hospitals, for rate year 2009, most of the other hospitals went up, BMC went down. In fact, its rate went down 25% from what it had been in the prior year. So we don't necessarily, some hospitals get more, some hospitals get less. But the point is that what the legislature had done in a variety of different mechanisms is to treat not only, Justice Lank's question, not only treated the DSH hospitals as requiring special care, if you will, special undertaking by the Commonwealth through rate reimbursement, but BMC itself was in a special category.
I just ask a follow-up on Section 11, your argument there. You point to the financial requirement in Section 11A, but that's defined, of course, earlier in the statute as reasonable operating expense, et cetera. So the word reasonable does go into the financial requirements being met. Apart from that, I don't really see in your argument anywhere that you are directly saying that this is inconsistent with 42 U.S.C. 1396A 30A. You're not arguing that the two are inconsistent. Your argument is focused on how 11A was used to come up with the SPAD rate.
They're not at all inconsistent. They're very compatible. And yes,
So you're not making also a policy argument. You're not saying that the statute is inconsistent or that the enunciated policies are inconsistent.
Well, the SPAD rate amounts to a regulation. It's not just a sort of informal policy or informational bulletin.
And
right?
if it has been approved by the federal government, you were going to answer that question, what do you do with that, since it appears to have been approved?
It has been approved, Your Honor. The record is really silent as to what the Secretary, but what CMS had before it. I noted, for example, in the Supreme Court case, which was remanded back after the Ninth Circuit case, when the Solicitor General informed the and this letter is not in the record, but it's referred to in the Supreme Court decision. So if you went into you can see it. The letter from CMS transmitted by the Solicitor General to the court very clearly made clear that California paid special attention to the access question. There was a record there. Whatever the equivalent of the Secretary of EOHS in California paid special attention and made certain findings that the rates being imposed in California would continue to provide the access. This is the classic sort of chicken and egg kind of problem. The Secretary imposes a rate which we say amounts to a taking, dramatically puts us on a trajectory of failure, inevitably. It's a structural problem which the legislature anticipated. The Secretary has not fixed. But what's happened is we have no remedy under the Superior Court's decision to even get our day into court to look at, for example, what did CMS have in front of it? What was the record? Were the access considerations really taken into account? See, my time is up. Thank you. I've managed to spill water over here, so if somebody... You have a towel or something? Did not get it on the microphone.
Attorney Lundberg.
Thank you, Your Honor. I represent 3 community hospitals, Holyoke Medical Center, Brockton Hospital, and Quincy Medical Center, which also qualify as disproportionate share hospitals under Chapter 118G. And each of these hospitals, it's alleged in the complaint, serve significantly impoverished areas, especially the Holyoke and Brockton hospitals, and are suffering extreme financial distress as a result of the inadequate Medicaid rates that are provided by the Secretary. In this case, we are not challenging the Secretary's exercise of discretion at all. This is a pure statutory violation claim. The trial court did not address the merits of the statutory claim, and it need not be decided by this court on appeal, but I think that it's important for the court to understand the egregious nature of the violation. Our claim, the very purpose of Section 11A, is to recognize that DISH providers, because of the types of patient populations they serve, experience costs and financial requirements that are different and higher than those experienced by non-DISH hospitals. The Secretary has violated this requirement by basing the DISH Medicaid rate on the statewide average cost of discharge based on the costs experienced by non-DISH hospitals rather than on, excuse me, the financial requirements directly of DISH hospitals, which is what Section 11A contemplates. And this is a blatant disregard of the statute, we contend, because it irrefutably begins from the wrong point. Non-DISH costs versus DISH financial requirements.
Doesn't it make up for it with adjustments later?
Well, some adjustments are made, yes, on a per hospital basis, but our contention, which we didn't get a chance to develop factually, is that those adjustments do not account for the basic statutory violation that occurs at the outset. They started from the wrong point. So after that, the adjustments they make are not sufficient to actually satisfy the reasonable financial requirements of DISH hospitals. So that's our claim, that the court should address the statutory violation. Was it correct for the Secretary to use the non-DISH costs as the basis for setting the DISH rates? Or conversely, as we claim, was the Secretary required to start with the financial requirements of DISH hospitals only. That's the issue that needs to be decided by the trial court.
And what does the statute say as to that calculation?
Pardon me?
What does the statute say as to that calculation?
The statute says that the rates set for DISH hospitals, for DISH providers, shall equal the financial requirements of DISH providers, and the definition, we grant you, of financial requirements includes the concept of reasonableness. But that does not mean that the Secretary was free to start from an analysis of what non-DISH hospitals experience in terms of cost. That's the whole point of Section 11A. Otherwise, there was no point in the statute being giving DISH hospitals that special status.
You said earlier that you're not challenging the Secretary's exercise of discretion, but the statutory word you're focusing on is reasonableness, and isn't that the very essence of discretion?
Your Honor, I am acknowledging that once the Secretary starts from the correct point, which is DISH costs, not non-DISH costs, then in setting the standard and determining what is reasonable for a DISH provider, the Secretary has discretion. But our case starts before that. Our case goes to whether or not the Secretary had the option to choose that starting point, which we say under the statute she did not. Once she gets into exercising her discretion as to what is a reasonable cost, what is efficient, what is not efficient, there may be another case there, but that is not this case. Our case is really a single issue having to do with whether the Secretary violated the statute by using non-DISH costs as her basis.
Maybe it would be helpful if you could tell me how a reasonable capital and working capital costs is different for your hospital than it would be for statewide hospitals as a beginning point, that you couldn't then, once you had that reasonable working capital cost figure, add to take account of the differences of your hospitals?
Well, I think I have two answers to that. One is the statute acknowledges that the types of costs and expenses that DISH hospitals experience are much higher than what a non-DISH hospital experiences. Therefore, a reasonable capital cost for a DISH is going to be, is required to be acknowledged as different and higher. And the question of why can't the adjustment be made when you start from the wrong statutory basis and add additional costs to acknowledge the DISH status, I think is a factual one, which if we go back to reset the statute, to address the statutory issue, we could develop as to, that would require showing by us that our financial requirements are not being met. But in terms of the statutory issue, that's a simple one-issue claim. And that is what we're asking the court to rule, is to direct the Secretary to start from the right premise and then make the adjustments that are within her.
This sounds a little bit like a political question. The statutory has set a rate, and the rate gets incorporated into the contract, and you can decide not to accept the contract.
Well,
right. And you can complain bitterly about that, and you can complain to the governor that the Secretary is got this wrong, and we're not going to sign this contract, and no one's going to sign this contract, and the system is going to collapse, and that might make a difference.
Well,
so it sounds more like a political issue than
I think the answer is
issue.
The legislature has spoken in Section 11A. The legislature has stated how it believes DISH providers should be treated. And that is what the Secretary is ignoring. Whether or not we could ultimately get relief from the legislature really is not the question. The statute speaks to what the Secretary is supposed to do, and the Secretary, we assert, is not doing that.
So would that be a ground? So that would not be a ground for you to essentially challenge the rates at the federal level? I mean, is there a process by which you can challenge these rates at the federal level?
Well,
saying that they're inconsistent with the Medicaid statute.
The case recently decided in the Supreme Court suggests that you could sue HUD, for instance, under the APA for approving the state plan, which was not an issue in this case. It was never raised by the Commonwealth below. But what I would say is whatever the state plan does, it does not address the issue of state law. Whatever the federal approval of the state plan does, it does not address the issue of whether the Secretary is in compliance with Section 11 of Chapter 118G. The federal government does not look at that issue, and that's the issue before this court. Now, with respect to the contract, one of our claims is under the statute itself through declaratory judgment, which I think is clearly available to the parties here. And this court has regularly recognized that direct statutory violation claims may be brought as declaratory judgment actions without there being a separate jurisdictional basis in giving jurisdiction in a statute. But as an alternative to the declaratory judgment claim, the plaintiff's contract claim was very important, but it was subject to pretty much a catch-22 in the trial court. The trial court ruled there's no action under the statute and under declaratory judgment because the statute contemplates that it will be implemented through contract, thereby presumably giving rise to a breach of contract claim. However, the trial court also ruled that once those contracts are executed, they cannot be revised, and the parties cannot bring a claim that the contracts violate the statute. Well, I think the fact that the contracts incorporate the rates being challenged is not the end of the story, precisely because the Secretary was not permitted to enter into a contract which incorporated illegal rates. 118G Section 11 specifically says the Secretary may contract, but must contract in compliance with 11A. And the contracts themselves specifically state that the Secretary agrees to provide reimbursement as required by law. And so what this means is the Secretary was required to contract and did contract with my clients to provide a rate that was legal. If it turns out when the numbers are crunched at the end of the day that the rate was not legal, was not in compliance with Section 11A, then the Secretary is subject to a breach of contract claim.
Well, and why wouldn't that lie?
Pardon me?
Why wouldn't that breach of contract claim lie if you say a specific clause of the contract is violated?
And that's exactly what we did claim here.
Okay. A specific clause of the contract, not some other statutory implied
yes.
contract.
We relied on the legality requirement in the contract itself. The trial court said that because
so the Secretary contracted to act legally under a certain provision.
Correct.
She has not, therefore she has violated.
Correct.
Contract.
And she also said that my clients voluntarily entered into that contract with illegal rates, basically. And just briefly, I see my time is up. With respect to my clients, while we don't have the statutory imperative to directly to treat the poor, I commend you to our brief because our claim is that we have a multitude of regulatory provisions that are administered by the Commonwealth, the effect of which is to give the Commonwealth the option to prevent the plaintiff hospitals from leaving the Medicaid system. So any choice about our hospitals' participation in the Medicaid system is with the Commonwealth. Our hospitals do not have that choice. If they ever sought to leave the Medicaid system, they would be required to get a myriad of regulatory approvals, and they would be subject to severe scrutiny by the Attorney General's office, since all of them are public charities and required to provide care to the poor. So, as Mr. Stern said, they're on the horns of a dilemma: accept inadequate rates or operate in impoverished communities, be required to treat the poor, but have no reimbursement for it. That's what they face. So it's not a voluntary choice on their part. I see my time is up. Thank you.
Thank you. Attorney Salinger?
Good morning. Having agreed to accept Mass Health's rates as payment in full, these plaintiffs cannot go to court and seek damages for almost $200 million on the theory that the rates should have been higher. As this court correctly held in Hennessy, providers' participation in the Medicaid program is voluntary as a matter of law. That is subject to the condition, both by contract and by statute, that the provider accept the rates as payment in full. With respect to the hospital...
Can these hospitals withdraw from the Medicaid system? Can these hospitals stop treating Mass Health type patients? Can these hospitals stop treating all comers?
The last question, let me just take separately with respect to emergency care. Yes, these plaintiffs, all hospitals, could choose not to be part of the Medicaid program.
So the Commonwealth's position basically is if they did that, they could retain their status as nonprofit hospitals, acute care hospitals. That's not a problem.
If they are showing that they're meeting their mission in some other way, certainly. BMC, for example, has started their BMC HealthNet plan. BMC and the HealthNet plan together get about $1 billion a year from the Medicaid program. About 80% of that, BMC is meeting its mission by providing managed care through BMC HealthNet plan. There are lots of ways that hospitals can meet their mission. Now, the Commonwealth, of course, is thrilled that all 64 hospitals in Massachusetts, including all 23 disproportionate share hospitals, choose year after year to participate in the Medicaid program. We think that's a good indication that these rates are sufficient to keep them in the market. That's, in fact, what is happening.
But in order to leave the Medicaid program, do the DSH hospitals have to go through significant regulatory obstacles, as Attorney Lundberg suggested?
No, that's incorrect. The Department of Public Health regulations that the Holyoke hospitals talk about have nothing to do with participation in the Medicaid program. They have to do with buying new buildings and completely changing the way that services are delivered. The voluntary Attorney General guidelines for hospitals to provide charity care expressly state they're voluntary and expressly state that no hospital has to participate in any particular program to meet them. With respect to the statutory claim by the hospitals under Section 11 of Chapter 118G, the Superior Court was right to dismiss on the ground that there's no private right of action here. The legislature made that abundantly clear.
So it's unreviewable?
It is unreviewable in court, much like in the Cummings decision, where this court held that a decision not to require an environmental impact report, it's not unsound.
By whom is it reviewable?
It's reviewable in three ways. First of all, the Secretary is charged with setting these rates, exercising her discretion to make sure that the floors are met. Secondly, this is the ultimate policy decision for the legislature. If the legislature believed that some or all hospitals were not being paid enough money, the legislature could do something about it. Instead, what the legislature has done is directed the Secretary to take all measures possible to keep Medicaid rates as low as possible. Third way, although this is a state law provision, it really does echo the requirements of the federal Medicaid statute, that the rates have to be high enough to bring not every provider into the Medicaid system, but enough providers so that Medicaid patients have the same access to services as non-Medicaid patients. Those rates are reviewed by the federal Secretary of Health and Human Services. The detailed methodology that resulted in these rates was in fact submitted. It was approved in August of 2009. The plaintiffs did not attempt to convince the federal Secretary to disapprove them and has not challenged that approval. So in those three different ways, the statute it comes to life. And of course, if it really, truly were the case that a plaintiff hospital felt that it could not serve Medicaid patients at these rates, it could choose not to participate in the program.
But if, going just to 11A, we're talking about DSH hospitals, and the legislature has made clear that that system of reimbursement for DSH hospitals is to be different from the system.
We disagree with that, Your Honor.
Well, assume for a moment that it's correct, that the legislature has distinguished DSH hospitals from other hospitals in the manner in which they're to be compensated. And the Secretary has chosen an interpretation of that, and she follows it. Unreviewable? Her interpretation of that law is unreviewable?
So if I could be clear about what the special requirement is, it's essentially an undefined floor. The legislature has said that for DSH hospitals, the Secretary needs to make sure that their rates are no lower than the reasonable cost of serving Medicaid patients, and has made clear in the statutory scheme as a whole that reasonable costs mean the cost to be borne by an economically and efficiently operated hospital. 11A is silent as to methodology. Legislature leaves it up to the Secretary to figure out what the level should be and what methodology to use to get there. 11A is also silent with respect to non-DSH hospitals. There's no statutory requirement that DSH hospitals and non-DSH hospitals be treated differently. There's a floor for DSH hospitals, There's no floor for non-DISH hospitals. In theory, the Secretary could go below reasonable cost, but she's chosen not to. She's adopted a methodology to make sure that all of the hospitals in the Commonwealth get rates that are above the floor that was defined for non-DISH hospitals. There's no factual allegation in this complaint plausibly suggesting that that floor for DISH hospitals has not been met. The mere fact that the same methodology is used to make sure that all hospitals are above the floor is not a problem. And the suggestion that the legislature has specified that the Secretary must, as a starting point, look at the DISH hospital's own costs is incorrect. The kind of cost variations that the legislature presumably had in mind why it might be more expensive for DISH hospitals to treat their patients than others are the kinds of things that are specifically accounted for in what the Secretary calls the case mix adjustment. One might think that poorer patients might show up with more serious diagnoses, primary diagnoses, secondary diagnosis, might have more severe illnesses, might have more expensive procedures that they require. All of that plus age and sex are taken care of hospital by hospital. The hospital-specific capital costs are reflected in the methodology. That's why when you look at that list that's in the record of the hospital-specific rates, every hospital has a unique rate because the real costs revealed by the data to serve their Medicaid patients are accounted for. Nothing in Section 11A mandates any kind of methodology, and certainly there's nothing that mandates starting with just the historic costs of DISH hospitals as opposed to starting looking at all hospitals and then taking legitimate hospital-specific variations into account. Now, Justice.
Go back to the floor.
Yes.
Describe the floor. How did you describe it? Can't go below the...
It's not a dollar number, and it's not a precisely defined litigible concept. It is, you can't go below the financial requirements of serving your Medicaid patients, financial requirements defined to mean reasonable cost in the context of the statutory scheme that specifies in multiple places that the Secretary should be looking at the costs that are needed by...
Whatever the Secretary does in that regard is unchallengeable.
It is unchallengeable in court. It's challengeable at the legislature. It's challengeable at the federal government. Congress made the same judgment as the legislature. On the federal side, the decision about whether the methodology used by each state to set Medicaid rates is reviewed by the federal secretary. That secretary, like our secretary, has the kind of technical expertise in these very knotty policy problems that legislatures reasonably conclude are not ordinarily shared by Superior Court judges or by this bench, and has said this is the kind of thing that needs to be figured out in that forum. We should note a bit of history very briefly. BMC points out in his brief that the world of hospital rate regulation changed in 1991. They're right. Before 1991, the Rate Setting Commission set all hospital rates, not just what the state pays, but what the hospital could charge private insurers and HMOs. And that then was subject to judicial review under Chapter 30A. And this court reviewed a lot of those kinds of cases. In 1991, the legislature said, you know, for hospitals, we don't think that's the right system anymore. We're going to deregulate. We're going to let hospitals negotiate their own contracts with private insurers and with HMOs. And with respect to the Medicaid program, it was back in 1991, the legislature specified those rates, unlike other rates still set by the Rate Setting Commission, are not to be subject to judicial review. The legislature specified that, and we now see it in Section 9 of Chapter 118G.
So who has his or her hand on the pulse of these individual hospitals to make sure that the individual rate is, in fact, a healthy rate?
The legislature has charged the Secretary of Health and Human Services to have her finger on that pulse. And she's been doing a good job because despite the complaints of these plaintiffs, for the past 3 years, they remain in the program. They haven't left the program. They haven't gone out of business. And it's undisputed that all 23 of the DISH hospitals, all 64 of the hospitals in Massachusetts choose to participate in the Medicaid program. So the legislature has specifically charged the Secretary with a balancing act, making sure that the rates are high enough to draw hospitals into providing service to Medicaid patients, but not so high that we're spending more money than we need to. We need, of course, the Commonwealth has lots of things it needs to spend money on, and this isn't the only one. That's why the legislature has both said, here's a conceptual floor for DISH rates, not precisely defined. Secretary, you need to figure it out. and at the same time specifically instructed the Secretary year after year in that line item language that she has to take all measures possible to make sure that all Medicaid rates, including the ones being challenged or sought to be challenged here, are as low as possible, in the sense of being no higher than the cost that an efficiently and economically run institution would occur.
Can a hospital go to the Secretary mid-year and say this rate isn't working?
The hospitals are in regular communication with the Secretary. The rates do get adjusted mid-year. Indeed, this lawsuit comes out of a challenge to a mid-rate year adjustment that reduced rates, so it made the hospitals unhappy. There are all kinds of mid-year adjustments that can and do happen. Hospital finance is a very complicated business. If the legislature had created a private right of action, which it most certainly did not, it's a little hard to think through what a Superior Court judge would do. How would a Superior Court judge say, you know, I think the Secretary got the rates wrong, I'm going to set them going forward?
Does BMC stand in a different posture because it has its own legislation with its own mission to...
No, Your Honor. The statute that BMC refers to, Chapter 147 of the Acts of 1995, imposes no obligations of any kind on BMC. What it was an authorizing bill. It authorized the City of Boston to create this new entity, the merged hospitals, and indicated that the hospital should have a mission going forward. There's no statutory requirement that BMC do anything in there. If, hypothetically, BMC decided to pull itself and its managed care organization out of the Medicaid program, nobody could sue them. The Commonwealth couldn't bring an enforcement action. There'd be no right of action. This was a statute that said, City of Boston, if you want to create this new entity, we're going to allow you to do it, and here's the general parameters of how we envision the entity. There is no mandate there any more than there is a mandate on any of the other plaintiff hospitals to participate in the Medicaid program.
But there's certainly a mission statement that's
well, all of the nonprofit hospitals have mission statements. This mission statement is to serve all in need of care, regardless of status or ability to pay. There are other parts as well. But it's up to, just as it's up to the Secretary to set Medicaid rates, it's up to BMC to figure out how to carry out its mission. As I indicated a few moments ago, today, in large part, BMC is carrying out that mission through this new and growing managed care organization that just announced it's going to start trying to provide service to Medicaid patients in New Hampshire. So there's an evolving mission there. It's up to BMC to figure out how to meet it. The Commonwealth is quite pleased that BMC continues to participate in the Medicaid program.
But if they did not, are you saying that there is no arm of the Attorney General's office that wouldn't be seeking to change that? To say that that was not in compliance with its mission, to challenge its status as a nonprofit hospital? Or, I mean, there are no consequences to its doing that?
The Commonwealth cannot force a hospital to participate in the Medicaid program where the legislature has specified in Chapter 118G, Section 36, that participation is voluntary. Every provider, including every hospital, has to choose to participate in the Medicaid program. So
if they don't participate, there is no action that the Attorney General will take or can take against the hospital for doing that?
If a nonprofit hospital decides it's going to serve its nonprofit mission in some other way than participating in the Medicaid program, that would be permissible. The Commonwealth cannot.
What other way would there be?
A hospital could choose to focus only on Medicare patients, on the elderly poor, only providing managed care services as opposed to the kinds of service that BMC and Holyoke Medical Center, unlike the BMC HealthNet plan, provide. But again, these rates, in fact, have succeeded in convincing these plaintiffs and the other 60 hospitals in Massachusetts to continue to participate. If I could switch quickly to the federal claims, because there's a point that is in our brief, but I really want to emphasize. The easiest basis for upholding the dismissal of the claims for damages under the federal Medicaid statute and the Supremacy Clause is that it's barred by the Commonwealth's sovereign immunity. The Supreme Court held in the Florida case that sovereign immunity bars a claim under federal law against a state on the theory that Medicaid rates are too low, directly on point. This court, in Lopes, held that the Federal Medicaid Act does not abrogate the state's sovereign immunity. Now, these plaintiffs say, oh, but we're not suing under the Federal Medicaid Act. We want to sue directly under the Supremacy Clause. Supreme Court has dealt with that. As we point out in our brief, in Alden versus Maine, the court held that the Supremacy Clause does not abrogate states' sovereign immunity. And back to this court's holdings in both Morris and Lopes, whereas as under Alden, a federal claim could not be brought against a state in federal court because of the state's sovereign immunity, Morris, Lopes, Alden make clear that the same claim cannot be brought against the state in state court. So a very easy way and very clear way to deal with that federal Supremacy Clause and federal Medicaid statute. It's barred by sovereign immunity. To the extent that, well, let me phrase it a different way.
As to damages.
I'm sorry?
As to damages.
Well, as to damages and
Only.
as to backward-looking.
Right, but not as to forward-looking.
Right, and there is no claim for forward-looking relief. These claims are for rate year 09 and earlier. There's no claim in either of these complaints for forward-looking relief. If there had been a claim that in the future, declare that the way these rates are being set violates federal law, that could not be brought under the Supremacy Clause either, as the Fifth Circuit correctly held in that equal access for El Paso case, because this is not a claim that there is some state law or rule or regulation that conflicts with federal law. They're not challenging the state law. They're trying to enforce the state law. You can't, under the Supremacy Clause, bring an affirmative claim challenging a particular rate. Third alternative point for the federal constitutional claim, there's no facts alleged plausibly suggesting any violation of the federal Medicaid statute. Again, the provision we're talking about, 42 U.S.C. 1396A, A, 30A, does not roll off the tongue easily.
I thought that the plaintiffs were taking the position that the Secretary's interpretation of the state statutes are in conflict with the federal statute.
No, they're saying that the rates set by the Secretary violate the federal law.
By virtue of the Secretary's interpretation of the state statutes.
They're not asking for relief that invalidates the state statutes. Yes, separately they are saying that the Secretary misreads state law, but their claim is not a claim that a state law conflicts with federal law. Their claim is a claim that state law is just fine, we just don't like the rates, even though we agreed to accept
State law as properly construed would be okay.
That is the essence of their claim. That's right. And of course, our position in terms of the state law is that it is properly construed.
I thought you just said a minute ago that the rates essentially had the status of statutes, no? Regulations?
I'm not sure what I said that you're referring to, Justice Cody. I'm sorry. I believe that the lawyer counsel for BMC suggested the point you were just making, not that I had. I think we would disagree with that. I think rates are rates. Rates are not a regulation. Rates are not a law. They can say that it's akin to a law, just as in a footnote, BMC argued that they really did have a certiorari claim because the rates set here were akin to a quasi-judicial proceeding. But it wasn't a quasi-judicial proceeding, and the rates are not a regulation. They're not a law.
Okay.
The only thing that this part of federal Medicaid law requires is that the rates be high enough so that there are enough providers for Medicaid patients to get service. There's no allegation that the rates don't accomplish that, given that every hospital chooses to participate. One more point, observation on the so-called takings claim. This court's holding in Cabot, although it was not a takings case, it was a contract common law duress case. The principle's the same. The court explained at some length why it is that reacting to economic circumstances or economic pressures does not mean that an action is involuntary and does not turn the signing of a contract into duress. Well, the same is here with respect to, true here with respect to the takings claim. Any belief by the plaintiffs that, well, given our economic circumstances, we really need to participate in Medicaid even if we don't like the rates, doesn't stop their participation from being voluntary as a matter of law and therefore making it impossible for them to assert a takings claim. Before 1991, hospital rates were like public utility rates and subject to judicial review. But there's no confiscation claim that can be brought here now. Massachusetts is not acting as a regulator. Massachusetts is acting as a customer. The Secretary is saying if you want to sell services to the Medicaid patients that we're responsible for making sure are served, Here's our offer, and if you want to do that, participate, that's great. That is not a rate regulation subject to takings challenge under the state or federal constitution.
But subject to this floor that you're talking about.
Subject to this conceptual floor, not precisely defined, that the secretary is charged with putting flesh on those bones by figuring out how to implement it and what it means.
So if the plaintiffs came and said, we can establish that we get paid 64 cents on the dollar of our costs, you would say, well, you better run more efficiently. You're not obviously living up to the efficiency standards, or would that just be sort of raised in the negotiation as a negotiating position?
Well, first of all, to be clear, the 64% alleged in the BMC complaint is not Medicaid patients. They say for all of their public sector patients. And, you know, if Medicare is paying too low, Medicaid can't be blamed for that. Medicaid only pays for its patients. So there's not even an allegation in the complaint that they're being underpaid for Medicaid patients. But yes, Justice Cordy, this is not the institution's own costs. It's the reasonable costs, the costs of an efficiently and economically run institution. If it were true that the reasonable costs of serving the Medicaid patients at BMC are lower than what BMC is actually spending, then there's a problem, but it doesn't mean there's a problem with the rates. Thank you.
Thank you.